Now I will demonstrate how the concept of partial interest, tenancy-in-common properties fit into a living trust and how a client with a partial interest or tenancy-in-common interest, which is intended per agreement, by agreement with the owners, the other tenants-in-common owners, to be separate interests, and how that would fit into filling out this form so that the clients could then transfer their TIC, I'm going to call it a tenancy-in-common interest, to their trust. So if a client, let's say it's a married couple, again using the same section here for a couple, bought a property with another individual, and let's say they went halfers with that individual because it's a 2-unit property, a duplex. One, let's say the single woman that they bought this property with paid 50% for the property, and the couple, our clients, paid the other 50% of the property. They're half owners, husband and wife half owners, technically 25% each for the husband and wife, and then the other individual is 50% owner with tenancy-in-common interest. And it has to say, well, it doesn't have to say tenancy-in-common on the deed. In order to be a tenancy-in-common deed, the property has to be, it basically has to show the individual's names, who owns the property, and it must not have the words as joint tenants. Technically, by law, California Board of Equalization law, which pertains to property tax rules and regulations and laws, if the deed does not specifically state as joint tenants, it's automatically a tenancy in common. So if it says that husband and wife and a friend of the couple, a third person, bought the property as bought the property together, and it mentions their names, husband and wife, and then Maria Sanchez, a single woman, and it doesn't say joint tenancy, it's going to be an equal share tenancy in common. 33% for the wife, 33% for the husband, 33% for the friend as tenants in common. In this case, that might be a mistake that the owners, the husband and wife and the single person, made upon purchasing and did not insist to delineate the 50% going to Maria Sanchez, the single woman, and the other 50% going to the couple. So if that is a mistake, they're going to have to resolve that issue ahead of time. I will detect these types of potential wrenches that could derail the process of doing this living trust for a client or for some clients. So, but in most cases, a tenancy in common will specifically state 50% to the husband and wife, the husband and wife as to an undivided 50% interest, and Maria Sanchez, a single woman, as to an undivided 50% interest, comma, as tenants in common. That's usually how the title would vest. So in that situation, the couple here is going to put 50% of the property, their 50% interest, into their trust. So you would select that currently the property is a tenancy in common. It's a partial interest transfer that we're making to the trust. And let's say both husband and wife are on the title, put both their names, and the same kind of options come up pretty much. This does confirm whether or not there are other individuals on title. In this case, the answer is no. Are clients the only individual on title? No. Husband's wife, wife's name as it appears on the deed. Confirm whether you spelled it correctly here as it shows on the deed. If this is a primary residence, parcel number, address of the property, county first, then the city down here, property tax bill. This will likely be a quitclaim deed as well. Quitclaim deed is fine for this. And of course, if you have the legal description, enter it here. Okay. I hope that clarifies that particular option and the concept behind tenancy in common and partial interest transfers for our trust clients into the trust.